I think today, for some reason, technology is slightly playing a little havoc with all the speakers, with all our internet connections, but let's just hope it's going to be seamless for the rest of the summit. We'll manage that as well. Let me also quickly inform you, we're moving on to the alternatives available for the resolution of corporate stress. That's the topic of discussion. Quickly, our speakers joining in will be Anurag Das, Managing Director and CEO, International Asset Reconstruction Company. In fact, he's someone who comes with more than over 2 decades of experience in the field of distressed and credit investing and has led investments in some of the most complex global insolvencies across US, Europe, and Asia Pacific. We also have with us R.K. Bansal, who is a Managing Director and CEO, Edelweiss Asset Reconstruction Company Limited, who comes with more than 33 years of prolific experience. We have with us Mr. R.S. Sachdeva, President Group Legal with the JK Organization, who brings in a wealth of 28 years of experience as a corporate lawyer. We're also joined by Aashit Shah, who's a partner with J. Sagar and Associates, and he's been practicing law since 2001 and has been with JSA since 2005. We're also joined by Anoop Rawat, partner with Shardul, Mangaldas, Amarchand, who in fact comes with more than 17 years of experience. And we are also joined by Krishan Singh Barguzar, who's the CGM with SBI. And of course, now we will have our session moderator. We have Dinkar Venkatasubramanian, who's a partner in head restructuring and turnaround with EY Restructuring LLP. And he comes with more than 20 years of experience. So here are our prolific set of speakers joining in. And it's also time for me to bring them all on the main screen over here. I think it's like a marathon of speakers joining us right now. Lots of speakers in store, lots of insights coming your way. And again, please use the discuss box to share your questions with us. Let's quickly bring in our speakers and let's get the session started. All right, so looks like all of our speakers are coming one after the other on the main screen. Let's also bring in the rest of our speakers very quickly. Yeah.
Where the join session is not appearing.
So you're already on the main screen.
Okay.
We're now on the main screen live for our audience. I believe that Mr. Dinkar needs to join in. That's right. I believe Mr. Dinkar is also here. So on that note, ladies and gentlemen, all of our delegates, but it looks like all our speakers are all set for another very interesting panel discussion. This session will be moderated by Mr. Dinkar Venkatasubramanian. So on that note, let me hand over the proceedings to you, sir. Dinkar, sir, over to you.
Thank you so much. Thank you so much, Kavya. Am I audible, Kavya?
Yes. I just have a quick request to all speakers. While Mr. Dinkar is speaking, if I can request you all to keep your mics on mute. The rest of you on mute. There will be a lot of echo or else. Perfect. Dinkar, sir, over to you now.
Thank you so much. Good afternoon, everyone. Very warm welcome to all of you to this panel discussion. Panel discussion on resolution toolset. What are the alternatives available for the resolution of corporate stress as part of this Legal Era Insolvency Summit 2020? My name is Dinkar. I'm a partner with EY in India. And we do have a very experienced and erudite panel with us today. Let me quickly do go around the table introducing everyone briefly before we get into the discussion. We have with us Mr. Krishan Singh Barguzar. He's a CGM with the Stressed Assets Resolution Group of SBI, the largest bank in India by far, and the largest seller of distressed assets and stressed assets in the country as well. So welcome, sir. We have Mr. Rajbir Sachdeva. He's the President Legal with JK Organization, has had a history with various large Indian conglomerates.
All right. So from what I see, I believe Mr. Dinkar's network connection has suddenly gone off. So we will try bringing him back here on the screen. So kindly just bear with us for a minute. All right, delegates, if you are all still with us, our moderators seem to have had a really bad network issue, and we are in an era where technology is actually unifying us, so we're completely dependent on the technology. So meanwhile, what I could do is I could request all of our panelists to actually set the tone in their thoughts with regard to this particular panel discussion. So if I can, before we can get our speaker, our moderator on board, before Mr. Dinkar comes back, while we're talking about these alternatives available for the resolution of corporate stress, maybe if I may please request our set of panelists. So if I could please start with Sachdeva, sir. Sir, if you could probably share your thoughts, set the tone for this topic, and then we can go on with every speaker till we bring Mr. Dinkar back. So Mr. Sachdeva, we'll begin with you. So you're on mute, sir.
Thank you, Kavya. Thank you very much. See, the panel is discussing on the aspect, how do we get over on the issue of after the suspension was introduced by bringing the section 10A under the IBC, and there was suspension of initiation of CIRP under section 7, 9 and 10. What are the alternatives? And this, initially it was for a period of 6 months till 25th of September. This notification has been further extended till December 24th. The other alternatives are available, and those are under discussions. The Ministry of Corporate Affairs has set up a committee to look into the possibility of bringing in the pre-packs under the current insolvency regime, which to my mind would offer faster insolvency resolution under the IBC. I think Mr. Dinkar is back. Let him start the panel discussions, and I'll join in as my turn comes in. Mr. Dinkar, over to you.
Thank you so much. Apologies, I was continuing to speak without realizing that I dropped off. So I just was introducing the panel, but maybe I'll keep moving on. I mean, our context is certainly unique as far as stressed assets in India is concerned. We've been troubled by an underperforming economy to the build-up of gross NPLs in the banking system. I think we had NPLs built up about 12% by 2017. The IBC came around, has been a fantastic framework, one of the best economic laws implemented in India, resulting in the gross NPLs of NPAs of banks coming down to 8.5% by March 2020, which is a testimony to the resounding success of IBC. I would say the most important positive of IBC was the impact on the mindset of the borrowers that it had. But IBC, though, has been almost the lone solution for stress over the last 3 years or so. Will it be able to cater to the mountain of NPAs that need to be resolved going forward? Would the system bandwidth, the judicial bandwidth be able to match up to the needs? Or is there a need for this resolution tool set to be expanded to other things like more of pre-insolvency frameworks like debt restructuring under the June 7th circular, more like pre-packs coming through, more operating space for ARCs to deal with stress along with the banking system? It would be interesting to hear the views of the panelists on this. And lastly, would IBC be best served if not used at all, catalyzing all stakeholders to find commercial pre-insolvency resolutions rather than going down the IBC path as a last resort? The matter that is complicating this whole stress dynamics in India is the pandemic as well. One of the reports of the RBI that came through, the financial stability report that came through end of July, said that the NPAs in the banking system could go up from 8.5% in March 2020 to nearly 12.5 or to 14.5%, which is an additional 4 to 6% of NPAs by March 2021 if things are not resolved, which means an additional 50 to 80 billion dollars in bad loans unless this is arrested. To address the problem, obviously the central bank has provided a 6-month loan moratorium, ban on insolvency admissions, and other economic and fiscal measures. And also, and most importantly, this OTR scheme that came through in August 2020. While they will support to some extent to avert the banking problem and maybe the NBFC problem that would have had, it'll be interesting to see how the corporate liquidity problem is resolved as this plays out and where the additional liquidity is going to come through and the opportunity for investors there. In summary, I think the next 1 or 2 years are fascinating space for India, for the Indian businesses, the financial system. I mean, they are battling through the pandemic-led stress, of course, but the war against the backlog stress is still continuing. The panel here today, we'll try and unpick some of these puzzles while specifically focusing on impact of suspension of new admissions on resolution of stress, how are banks dealing with it, how are investors dealing with it. Secondly, pre-insolvency alternatives available today and which are likely to be available going forward for the resolution of stress. Third, what are the challenges that are being faced and therefore them not being used as extensively as they could have been. And lastly, how could this become better? How could these mechanisms that exist become more effective in practice? So while we do that, keep your questions coming on the chat box. We will pick it up at the end. Moving on to my panelists here. So I will, first of all, I would maybe ask Anurag to comment on, we've had, while the stress has been increasing, there is the backlog stress and the pandemic stress. But how do you see, Anurag, the impact of the suspension of new admissions on the resolution of stress? What has been, what is the impact on investors who are looking at this? How do they view it? What's the impact on businesses? And maybe we can then ask about the impact in the banking system as we move to Mr. Barguzar post that. So Anurag, over to you.
Thank you, Dinkar, and thank you for having me. I think I'll jump right into the impact of the suspension as you referred to. I think thankfully I hope I'm audible.
Yeah, Anurag, you're perfectly audible.
Dinkar, can you hear me? Okay,
yeah,
sorry.
Anurag, we can hear you very well.
So I think the important aspect is obviously the suspension finally was done in a manner that was reassuring to markets because prior to COVID, all the defaults that were there, cases remain admissible in that count. Now, as you know, the NCLT is very clogged. So there was a two-sided problem, I guess, with continuing to have IBC admissions. In theory, we would have been able to admit lots of situations, but one, the pandemic impact was widespread. So I think the impact of the suspension is moderate from the standpoint of how concerning it might have been if it was a blanket suspension. Let's get down to practicalities. Because there is a suspension on the admission and new defaults, and we'll see how the interpretation of whether this is a perpetual waiver for COVID defaults pans out. That could be a concern because it creates a perverse incentive for some companies to probably default deliberately. Now, you don't want the marginal consideration to start driving where this goes. But I think what you will see is, as this suspension comes to an end, hopefully some other mechanisms, which hopefully we're going to discuss here today, will have created some controlled release into the NCLT system. Otherwise, the real impact of the suspension will be overwhelmed, I think, when the suspension is lifted and by the wider impact of the pandemic. So I think the fact that IBC remains available as a mechanism is reassuring to everybody. IBC, I think, has done a remarkable job of moving the needle, but I think it's time for some further changes, both to accommodate the impact of the pandemic and to accommodate some of the deficiencies in the law, the regulatory setup, and in how IBC cases have been done relative to today's needs. So obviously, 4 years ago, this was a different situation. Today we have a wider need, both based on the pandemic and because the system has come along pretty far with respect to IBC insolvency resolution.
Thanks, Anurag. Mr. Barguzar, how do you see it from the banking system perspective? You are, as you see, I mean, the stress has been there and it's probably increasing. So the suspension of IBCs, how do you see that from a banking system standpoint?
Yeah, thanks, Dinkar. Am I audible? In fact, for last few minutes, I was disconnected.
Can't hear you, sir. Barguzar, sir, not able to hear you.
But I was able to hear him.
Yeah, he was audible. I think, sir, you are on mute right now. You need to unmute yourself.
Now, am I audible? Yeah, thanks, Dinkar. Good morning to everyone, and thanks for this giving opportunity to us to discuss this very hot issue. In fact, particularly as you said, that stress asset or NPA, it is a buzzword and it is a concern for almost each and every stakeholder in this, particularly in economy. And per se, this is for the banking sector. As far as this is a suspension of 7, 9, 10 section for some time, before that, I would like to take back for a moment that IBC basically started 2017. And now almost 3 years we are going to complete. During these 3 years, a lot of development happened. And this is more particular or more important. This is that one lesson this is taught to the corporate debtors or promoter of the companies that financial discipline is required if really they want to do the certain things. Particularly this ecosystem for the CIRP, IBC, that has also developed during these 3 years. Now this is after 3 years, or say now it is a pause button. This is our understanding. This is a pause button for and now we have to think about that whatever we have done in the past, whether it is in order or some kind of need to be brought in the system. And everybody is affected on account of COVID-19. This is suspension happen, this is section 7, 9, 10, and by insertion of 10A. This is for a limited clients. It is not applicable to all. It clearly speaks that the assets or corporates which are standard as on 25th of March, particularly this forbearance is given to them that lenders are not supposed to file a CRP application in the NCLT. And this is when is required, that is
Anoop, are you there?
Yeah, Dinkar, I'm there.
Okay, I lost Mr. Barguzar towards the end, so maybe you want to add on to that before we move on to the next.
Yes. Thanks, Dinkar. As Mr. Barguzar said that, the suspension is for the limited cases. for those cases where the default has occurred after March 25th. So as far as the cases where the default occurred prior to March 25th, or the cases which were already submitted to the NCLT before the promulgation of the ordinance, those cases are saved. There is a recent NCLAT judgment which reaffirms the second point, that if there were cases which had already been filed, they will not be dismissed. I mean, the cases where the admission has not taken place yet, they will continue to be heard because the ordinance is prospective in nature. But, just to delve upon the issue of suspension per se, see, all of us know that, NCLTs are clogged right now. And perhaps it's a kind of a relief to the NCLTs also to clear the backlogs as well. But, at the same time, if you look at the structure of IBC, the IBC structure is designed in a way which expects least intervention from NCLTs. Unlike the bankruptcy regime in US, where NCLTs, where the counterparts, their bankruptcy, sweeping powers to approve or reject the insolvency, the extent of the scrutiny for the NCLTs in India is very, very limited. In fact, in several judgments in Swiss Ribbon and others, the Supreme Court has now said that NCLT cannot revisit the commercial wisdom of the Committee of Creditors. So therefore, NCLTs do not have too much of a role to play there. So we need to see what is the cause for delay in approving the plans. That is one. The second, the reason why the insolvency is lagging is the admission itself takes more than a year in some cases. And that is the, I think that is one thing which is not related to any of the circumstances or the events that are happening today. I think the admission, the moment there is a proof of default, should happen automatically, which will sort of reduce substantially the time taken by NCLTs. Now, with this kind of role for NCLTs, putting a complete suspension on the fresh cases is going to only add on to the problem. We are just pushing the can down the road. Instead of, leveraging the progress that we have already made in the insolvency regime so far, putting a suspension is like a step backwards. I think we are in a great position now in the insolvency jurisprudence, where most of the issues have been ironed out, and now a very, very clear regime of how the things needs to move forward. By putting a suspension, we all only demotivate a quicker resolution, because it's not only the lack or the lack of insolvency regime or existence of a weak insolvency regime that motivates a alternative resolution. It is the robust insolvency regime which also motivates the alternative resolution. So I think that kind of a deterrence of triggering of an insolvency if the alternative resolution fails does not exist anymore for this period. And that is our biggest disadvantage, I would say.
Right. So thanks, Anoop. I guess what we're all tending to is that we need to have insolvency, but at the same time, we need to. I mean, as I often think about it, we have a carriageway lane of stress which needs to be resolved. And however good the two carriageway of IBC is, we need to expand the carriageway to let the stress flow and get resolved. And that's the case for expanding the tool set. So moving on to the next bit on. Aashit, maybe you can explain to us today as to, if you are either a banker or a business or an ARC or an investor, as the different stakeholders, what are the alternatives available today other than IBC to resolve stress, and what is likely on the anvil as well?
Sure. Thanks, Dinkar, for that. And good afternoon to everyone listening on this conference. I think in relation to the different alternatives which are available today, so you have different remedies depending on the kind of lender that you are. If you are a bank or if you are an NBFC, then the RBI has two circulars which apply for restructuring of assets. So the first one is the June 7th circular, which is the prudential framework on stressed assets. And the second one, which is a more recent one, is the COVID resolution framework, which is a circular which RBI issued in August and supplemented that in September. So these are two broad frameworks which are available. Again, both these frameworks apply to banks and certain financial institutions and NBFCs in India. These frameworks are not binding on other alternative credit providers such as ECB lenders, foreign portfolio investors, alternative investment funds, or mutual funds. So therefore, there is a limited set of creditors that can avail of this framework and who would be bound by the framework once the intercreditor agreement is signed. The difference again in these frameworks compared to IBC is this is more of a consensual framework where creditors sign up to an intercreditor agreement compared to the IBC where once a creditor files an application, the company is admitted into insolvency and all the creditors get bound by the process. If you are an ECB lender, a foreign lender who has given an ECB to a company, then you have certain alternatives and options available under the ECB guidelines to restructure your debt. If you are a foreign portfolio investor who has invested in Indian companies, or for that matter, if you are a listed NCD holder who holds listed NCDs of Indian companies, the SEBI has recently issued a circular just a few days ago, which deals with how can such NCD holders enforce security, and also how can they sign up and adhere to the intercreditor agreement, which is signed under the June 7th framework. So those are some alternatives available. Other than those, there really isn't a lot you can do. You obviously have banks and financial institutions, when they have NPAs or SMA2 assets, have the ability to sell those to asset reconstruction companies. Today, the ability for foreign lenders and foreign FPI holders to sell their debt to ARCs does not exist. But that is one avenue which we could consider. And, there has been a talk about pre-packs, and, maybe I'll leave that to Mr. Sachdeva to discuss. But that's another avenue which, may open up depending on how fast the government moves on that.
Thanks, Aashit. Bansal Saab, do you want to add more color to some of these? Because you've been trying to explore various aspects as well. So anything you want to add to that before I move to Mr. Sachdev? No, I can't see Bansal Saab, I guess. So Mr. Sachdev, maybe given your specific role on pre-packs and their development, could you please talk a little bit about how you see that, and maybe also another alternative within IBC that you had in mind?
Thank you, Dinkar. See, the alternative, and currently Ministry of Corporate Affairs has set up a committee to look into the possibility of pre-packs under the current insolvency regime, which to my mind will offer faster insolvency resolution under the IBC. A pre-pack is an agreement for the resolution of the debt of a distressed company through an agreement between secured creditors and investors instead of public bidding process. This system of the pre-pack has been quite prevalent in UK, Europe, in US. In India, this is now they will be introducing, and I am told Ministry of Corporate Affairs will be releasing a report. The committee will be setting up and placing a report how this will work. To my mind, in India, such a system would require that financial creditors should agree on the terms with the potential investors and seek approval of the resolution plan from the NCLT. Now, this the advantage which could be seen is this is an important alternative resolution mechanism to CIRP. But then there are drawbacks also. The main drawback which we could see was, which maybe we can see when it is announced, will be a transparency issue. Pre-packaged insolvency resolution will have a reduced transparency compared to what we saw in CIRP, as financial creditors would reach an agreement with the potential investors privately and not through an open bidding process. So this will raise a transparency issue, and maybe the litigations will start how people have to see that this is a transparent way of working. Second aspect will be the moratorium shield which was available under the IBC. That is not going to be available, and that protection will not be available in the pre-pack scheme. And the creditors, while the scheme is on, the pre-pack scheme is being under implementation, etc., or being negotiated, the creditors may enforce their rights and remedies while this negotiation is on the pre-pack scheme. Third aspect which I could see is Section 29A, which would be another issue in the introduction of pre-pack schemes in India. The fact that the debtor would be in charge of the process and not the IRP, and this would go against the basic essence of Section 29A. Since the company is going to be pushed into the insolvency by its own management, sometimes, in the pre-pack, and I guess, I don't know how the safeguards will be built, whether it will be sensible to allow the same management to alienate the assets of the company, which was not the case when we were looking at the CIRP, because the insolvency resolution professional used to take over the management and who used to administer the company. And that will not be the case. So this could turn out to be prejudicial to certain stakeholders. And I think in that scenario, there will be a stream of litigations in the pre-pack. But we are yet to see how this report comes out, what will be the alternative. It is too early to say how they will bring back this pre-pack in a way where it is clearly seen as a transparent way of working as an alternative to IBC.
Thank you. Thank you, Mr. Sachdev. I guess we are looking at some of these alternatives, as Aashit said, and as you mentioned. I think pre-pack is a very interesting option on the anvil. Can I just ask, commercial standpoint, before we move on to the challenges that are there in the current phase? I mean, I know pre-packs are currently, whether we go through the UK model, which is completely private, or we go through the US model, which needs a court approval, or a hybrid of that, which will give more transparency and stability. All of that is being discussed, as Mr. Sachdev said. We are awaiting the report. But as a potential investor, how do you look at pre-packs, Anurag? Anurag, you're on mute.
Thank you. I'll start by just mirroring Anoop's thought that a robust IBC resolution mechanism is what will encourage an alternative, and pre-packs definitely fall into that category. So if we think of pre-packs, I think there are two aspects. Mr. Sachdeva just referred to certain constituencies potentially being prejudiced if pre-packs are not done properly. I think the balance that will need to be sought, and hopefully things head that way, is creditor right protections need to remain very robust. And the alternative available to creditors, which is to take it into IBC through some process there, will have to be preserved in some fashion. On the other hand, I think the complexities of handing over possession to a RP and therefore kind of moving with the creditor in possession model we've had is something that needs to be seen. So I think the important pieces are creditors should be able to choose whether or not, as in other jurisdictions, a pre-pack is done. I think in India, we will require some sort of court approval to get the protections and benefits of IBC. I think there will be the sensitivity as to how soon after that you can actually put it back in IBC. Oh.
दिखाई दे रहा है
No,
लेकिन
sorry.
वो
Sorry.
Can I request everyone else
So,
to be on mute?
so
Sorry,
the
can I request everyone else to be on mute? Go ahead, Anurag.
sorry. I think there will have to be some sensitivity as to how soon after a failed or a blatantly failing pre-pack arrangement, the creditors will have the right to put a company back into IBC. So I think the challenges could be if a pre-pack essentially just strips creditors of lots of rights, they take a restructuring, and then the IBC avenue is unattractive. Pre-packs will probably fail. But I think preserving debtor in possession if the creditors are okay with it, seeing how that goes and having the alternative then taken to IBC could make for the best of both worlds, which is you have IBC available, you negotiate an arrangement that is adequate. If the debtor remains in possession, the promoters, management teams remain involved and are able to now start to deliver, we could have both. I'll close with one last comment, though, which is at the end of the day, it all hinges on whether we manage to create a reasonable market for these types of things, right? If it ends up being the same old, which is in form, we have all these things happening, but no one shows up to participate, then what you have is creditors with no alternatives. They stay in place, the promoters stay in place, and we go back to the days of a big haircut for creditors and all kinds of lack of transparency with the sort of information provided. And eventually banks will take a better haircut, nothing much else moves, and we're back to kind of BIFR 2.0.
No, I think pre-packs is a maybe a separate panel by itself. We need to get into the nuances of that, but certainly a topic. And I mean, if we introduce it today, I think my sense is that it will probably take some time to stabilize and be used in the way that we want it to be used. But worth an addition to this at this stage so that it can be practically used in some point at some point in time with the way it's intended. But moving on to what's on the table today, we do have the June 7th circular. We had the Feb 12th circular, or the Mahashivratri circular, as they say, which went away and transformed into the June 7th circular. It's been there for nearly 1.5 years now. We have the August 7th circular. We've had the one-time settlements as an option. We've had ARC sales as an option, as Aashit had outlined a little while earlier. So let's focus on maybe a couple of them and talk about the challenges that we're facing for those. We haven't seen more than a handful of resolutions under the June 7th circular itself. So maybe just Bansal Saab, if you're back, what are the challenges we are facing? Or if not there, then I'll probably move to Aashit. You've been assisting lenders as well as investors on this, or companies on this June 7th circular. And what are the challenges? Why are we not seeing? It was hailed as one of the great alternatives to come before it goes into IBC, but we're not seeing the kind of resolutions. A lot of them are stuck for some reason or the other. What are the challenges you are facing on that, Aashit?
So I think there are a few things, Dinkar, that are hindering a successful resolution under these. I think the first and foremost, as I said, is that this framework does not apply to all lenders. So it applies only to a certain limited set of Indian lenders, which is banks and financial institutions, whereas and NBFCs. Whereas the reality today is that there are so many other alternative credit providers in the market today. And especially where companies are in stress, you do find a lot of AIFs, FPIs coming in and giving debt to these companies. So this framework, when it does not apply to all those other lenders, a robust and wholesome plan to address all their needs is going to be impossible. I think that's one of the biggest problems today with the current framework. And I think one of the things that regulatory and government agencies need to do, and which is the need of the hour, is to figure out how all the lenders can come together. Because the IBC's appeal is that all creditors, whether you're a foreign lender or an Indian lender, are all on the table. This framework does not have all these guys, and therefore the domestic lenders will not be able to achieve any sort of resolution without the buy-in of the foreign lenders who are not party to it. So that's one major drawback. The second thing is that when you start a resolution under the June 7th framework, or even if you start one under the COVID framework, there is no moratorium on legal proceedings against the company. There is a contractual moratorium, but that only applies to lenders who have signed the ICA. So unlike the IBC, where once an insolvency process starts, there is a moratorium on legal proceedings against the borrower. There is a moratorium on enforcement of security, on transfer of assets. Even governments can't cancel licenses or permissions that they have given now if during the moratorium period for past dues. All of those don't exist in a June 7th restructuring or an RBI restructuring. And as a result of that, the restructuring process can be derailed if you have other creditors or other third parties filing any sort of legal proceedings against the company. So that's a second drawback of this process. The third is, and this has been, in the news in several large profile cases where erstwhile promoters and erstwhile directors of companies have been, blamed for siphoning funds. There have been allegations that there have been fraud, collusions, etc. The IBC now has a section which provides for immunity to any new bidder from past actions. There is no immunity available today to anybody who acquires a company under June 7th resolution framework or any other alternative framework. So that again is a big drawback, especially for international investors, because the last thing you want is acquiring a company, taking over the assets, and then getting a notice from the enforcement directorate or from some other authorities saying that there were frauds and we need to seize your assets, etc. So that is another big drawback on this framework, and I think the government needs to think on whether they should expand the immunity to such resolutions as well. And the last one is you need the cooperation really of the borrower to implement this framework. So in a situation where the borrower or the promoters are not cooperative, you will not be able to implement any resolution under this framework. Unlike the IBC, where once the insolvency process starts, the promoters are divested of their management and a resolution professional takes over. In this situation, you are still dealing with the promoters. So where you have cooperative promoters, the process will work, but where you don't have cooperative promoters, the process is unlikely to work.
Thanks, Aashit. Bansal sir, we have you back. So can I request everyone else to be on mute if that's okay, please? And so Bansal sir, in your view, why isn't the June 7th circular or the other pre-IBC alternatives working today on the ground?
See, the reason is basically, as I was telling, restructuring was always an option with the banking system. But up to now, when we had restructuring through CDR and all, there were few conditions which were being complied, which are even in Kamath committee report. Earlier also CDR used to follow. But then slowly a stage came where perhaps there was a distrust between regulator and banks, that as if the restructuring is happening only for a specific purpose, which of course partly was true, partly not true. So then the conditions which have been there in June 7 circular or even Feb 18 circular are things to some extent difficult to comply. The other issue is the provisioning at most of the time, unless there is a change of management, it continues. So banks have reached a high provisioning coverage, so they are not interested in that. My stand has always been that even if the account continues as NPA, what is the harm in doing a restructuring? But somehow this has gone into the system that unless I am able to upgrade, I will not be able to restructure, which apparently doesn't fit into the entire restructuring game. So I feel rating has been one issue, and sustainable debt and rating agencies also became very cautious after a few incidents happened. So today it has become a chicken and egg story. You can't get a rating, so you can't do a restructuring. So my always request would be like, say, let us try a restructuring even without upgradation, because only IBC may not be able to resolve all the cases. We should try all the options, whether it is settlement, whether it is sale to stress funds or sale to ARC, but maximum cases have to be resolved by restructuring only, I still feel. It should be able to work, but there are conditions. But even if you see August later circular also, there are also conditions, lot of conditions. So there are also limited options. So it flows from the regulator that perhaps they want to see that restructuring is done only in a very limited eligible cases. That's the challenge.
Got it. So I think, as Mr. Barguzar, if you're back, I think lender consensus, the complication and various procedural issues in a June 7 circular are making it difficult. Banks, lenders are not coming together to sign ICAs and bite into a resolution plan. So from your perspective as a lender, I know SBI has been a big proponent of the June 7 circular, and also now given maybe lack of valuations and investors post-COVID, you're also looking at other options like OTSs and ARC sales. So where are things not, I mean, despite the intent of the banks, which I know is there, why are things getting stuck from your perspective?
Hello.
Barguzar sir, we can hear you.
Hello.
We can't see you, but we can hear you.
Am I audible, Dinkar?
Yes. Yes, you're audible, sir.
Am I audible?
Yes,
Am I
yes.
audible?
Yes, sir. You're.
Am I audible now?
Yes, you're.
Hello. Hello.
Barguzar Saab, you are audible. Go ahead. Dinkar, we can't hear you.
Hello.
Dinkar, we are unable to hear you.
Hello.
Dinkar, you are not audible.
Barguzar साहब, आप सुनाई दे रहे हैं, you can continue please.
Hello.
You can continue.
In fact,
We lost him.
hello. Hello.
I think there's some network issues. Just picking up from where.
Anoop?
Yes, sir, I can hear you.
Anoop?
Yes, sir, I can clearly hear you. I can hear you. Yes, sir.
Achha, what is going on? What is going on? What discussion basically is going on? Can you little bit give me?
Sir, Dinkar was saying that, as part of the nationalized banks, you've always, favored the resolution under the RBI. So what is, where the things are stuck, and, what exactly you see the reasons why resolutions are not there.
Okay, right. Thank you. In fact, all session I missed out. Sorry, in fact, due to the technical and connectivity issue. Particularly, this is the regulatory guidelines issued on 7th of June 2019 for restructuring of debt. After this 12th Feb circular, it was a refined kind of guidelines. But one challenge we face, reason being we are in most of the account, we are the lead lender. And one challenge, this is the signing of ICA. Hello.
Yeah, you are back, sir.
Hello.
Yeah, we can hear you, Mr. Barguzar. Go ahead.
Particularly, this is one great challenge we face, that is signing of intercreditor agreement. This was one of the basic requirement under that circular, and everybody knows that particularly in corporates, there are multiple lenders and even multiple regulators also. So, as per the RBI circular, that circular applicable to the domestic, including ARC and NBFC, but this is foreign lender, even debt fund, mutual fund, etc., etc. So, this challenge was there, and we have taken up this issue with several forums. To some extent, basically, it was refined by way of issuing a fresh circular on 6th of August for the stress assets happen after COVID. But as far as the 7th June circular, this is one thing, and another, this is wherever additional funding is required to corporate to bring back the activity on the track. That is also one of the concern we face, that few lenders basically they are not inclined to sanction the additional funding. Then it is a question, then who will compensate that part? Sometime basically the borrower arrange the money through some investor by way of diluting his equity or some other, or replacing the existing lender. But this is also one of the concern. And the circular also provides for payout mechanism for the dissenting creditors. This is also not much clear how basically it would be kind of paid to the dissenting creditor, and most of the time the non-signing creditor to the ICA, they were making a provision, but this is not a adequate or kind of sufficient kind of thing, that making provision and they will not sign. This should be a regulatory kind of compliance, as it happened on the 6th August circular, when RBI gave a clarification in September, that not only additional provisioning, but it is a regulatory compliance, and during the time of compliance, during the supervisory review by the regulator, they will see whether they complied with or not, and according to the RBI, any penal provision is then they may invoke. So this kind of threat is required. So particularly we are facing this kind of thing. As far as SBI is concerned, we are really thinking for the restructuring. This is our first option, not today. From always, basically, this is first option for resolution of stress of any corporate or any borrower. Reason being, this is a economic activity. Until and unless bank will not come forward to revive that activity, it will hamper to a larger stakeholder, not only banks. There are so many people attached to a economic activity, not only lender and promoters. There are so many ancillary activity, ancillary units. There are so many employees, so many families are depending upon that. So this kind of thought basically in our bank, and right from beginning we are considering that. And to some extent, skill upgradation, our in-house skill upgradation infrastructure is available. But in most of the banks or lenders, we found that this is also a duty due to awareness and lack of skill. This is also one of the great concern for them as well as the other lender. Reason being, this should be having a consensus or a larger kind of say 100, almost 100% lender should be on the same page. This another. This is another thing. Another thing, if ICA is not signed, lenders have other alternate option, like anytime I can sell my portfolio to asset reconstruction company. That we have been exploring, but most of the time ARC is also inclined to take measures here. Particularly, they are also interested to take either full kind of control over that. Reason being, this is they want to revive the economic activity, and until unless control would not be there, then probably it is difficult for them also to revive and get back money, whatever they are going to invest. So these are few challenges based on the this 7th June circular, and at several forums we escalated this issue. IBA, RBI, DFS also, and I think the big firm like ENY, these people are taking our concern and observation to other stakeholders also, and this is creating a developing or improving the skill also. They are arranging some program not only for lenders, they are giving some guidance to the existing promoter of the companies also. Until unless promoter will not be in line, it will be very difficult to restructure and take it forward. Reason being, nowadays we found that economic activity is there, plants are good, and lender can come forward to restructure or whatever sacrifice or unsustainable debt is there to go with that. But in certain cases, the promoter puts some kind of condition, and sometimes those conditions are not acceptable to the lenders. That is also one of the concern. But this is one thing I would like to share here, that IBC has taught a lesson to the promoter as well as other stakeholder. Now they have diluted to some extent, and now they have come forward to settle or whatever resolution lenders are suggesting. Now probably over a period of time, position will improve, and it is I think during this year for new stress assets as per the IBC amendment by insertion of section 10A. So some temporary deferment is there, but at the same time for the old stress assets there is no bar, and we have been doing, if this option is not workable and not work out, then we are filing application in NCLT also for the previous or old NPAs.
Thank you, sir. That is, I would say, very, very practical issues you've highlighted. But my takeaway from that is very reassuring to everybody on the call, and I'm sure who are listening as well, that banks and the biggest bank is looking at restructuring as one of the first options before going into IBC, and you're putting all the weight behind that. So I think that's very reassuring to hear. Last couple of minutes, we have run out of time. So I'll ask Anoop and then maybe Anurag after that. Anoop, if you can talk about some of these challenges that Aashit and Bansal Saab and Mr. Barguzar mentioned, how are we trying to address it?
Yeah, hi, thanks, Dinkar. I think what Aashit said about the non-coverage of some of the important constituents of the lender group, and what Barguzar Saab said about the the issues around issues of additional funding, and there is no enough regulatory certainty about the priorities given to those additional fundings. Now, so therefore, what it means is that, right now we do not have a proper legislative framework which can, facilitate a efficient resolution framework outside IBC. So therefore, what we need to do is to have at least a legislative interference where, some kind of a procedural guidelines are issued, maybe by Reserve Bank of India, as a matter of, their supervisory role, with regard to the monetary control. But at the same time, I think what we need to understand is that, historically in India, the institutional lender group are the, one group, sort of, which is also called the JLFs, who decide on a lot of things. So we need to, I think, include the other lenders group also, like the bondholders, the bondholders or the PFIs and others. In what manner we can do that, I think that is something to debate on. But there needs to be a platform where all the lenders group can meet and a transparent mechanism can be developed for resolution. Now, a couple of things there. One is that, the existing framework of, JLF leading this whole thing has not proved too successful. So therefore, I think there needs to be an independent professional. Maybe, the same way you have an insolvency professional in the IBC. Similar, kind of a professional who brings everybody together, creates that kind of a platform, also undertakes some of the key activities like valuation exercises, so that, transparently the valuation can be arrived at. Also, the interests of, some of these lenders group who are not traditionally part of the JLFs, like bondholders and others, can be kept in mind. That needs to be created. And over and above, I think some kind of a mandatory provision which binds, which binds all the lenders, all the creditors to the decision taken by a majority, while keeping some of the safeguards there. Of course, some of these private lenders, the offshore lenders, bondholders, they would definitely have concern about a potential or a possible cram down provision without taking care of their interests. So therefore, I think we need to balance the interest and at the same time create a mandatory provision where the decision is binding on everybody, because we have seen so far that voluntary ICAs are not working. The resolution is not only about the negotiation between the corporate debtor and the creditors. The resolution also involves negotiation inter se the creditors, and that's also a very important part. Right now we have the creditors who may not be in the same position. Somebody may have a superior security interest, some may have lower security interest. So I think a transparent mechanism along with the mandatory provisions, that's the need of the hour.
Thanks, Anoop. Anurag, last 30 seconds to 60 seconds before we close.
Just a quick kind of recap. I'll just try and emphasize what we're lacking is a mechanism that's proving effective and getting better outcomes. And I think that a mechanism has to be the market. What is the ecosystem lacking with respect to market being there? To some extent in the past, capital was simply not there. Now there's capital available, but the capital's got to find avenues to come in, and they'll be very focused on the rights of creditors. So I think it's very important that those rights are allowed to remain solid, as IBC has put them in place, and not be diluted by an ICA forcing a cram down. All you'll do is chase investors away. I think I'll touch very briefly last on Mr. Barguzar's point. As things evolve, I think we need to try and make sure that more debt trades hands into distressed and other people who want to come fix these companies, so that they start to bring in management teams who are the only alternative to the promoter. It'll take some time, but I think some pre-pack plus other combination where over time both new management teams and promoters start to turn around will be required. But I think the answer is promoting a market by relaxing regulation rather than the other way around. The moment RBI starts to say, here's my IC, I'll cram you down, people will just not enter the market.
I think we have lost Dinkar. Over to you.
Yes. All right. So then, with your permission, gentlemen, is it okay if I can close the session then? Is that okay? Or were there any parting thoughts that were still remaining at your end? So Anoop, then, all right. So then I'll do one thing. I'll just go ahead and close the session because you're also out of time. And also our moderator has sort of vanished for a little while again. while he's come back. So let me just take your permission and close the session for now. I believe at individual level, the technology probably did not come in sync. But nevertheless, I must thank you all for sharing your thoughts with us.
Dinkar is there now. Dinkar is there. He can close.
Yes, sir. That's right. I can see him now as well. Yes, Dinkar. So over to you.
Thanks so much, everyone. I think running out of time is always a good thing, which means we had a lot to say. I certainly IBC needs to be, we need to expand to more tools. We need to make the existing tools work. We are in a good place, but as I close with, Robert Frost poem, the woods are lovely, dark and deep, but I have promises to keep and miles to go before I sleep and miles to go before I sleep. So we need to move forward and ensure that we keep expanding this tool set and making resolutions work. Thanks so much, everyone, for this engaging discussion.
Thank you very much.
Thank you, everyone.
Thank you.
Bye.
Thank you very much. And if I may request you all to click the exit
Thank
panel
you.
button, that will take you backstage again. So thank you so much for joining us.
Thank you.